Ho, 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 it's the Santa Shanty. Why is Santa in the shanty? Some of you may be asking. Well, let me tell you why. Santa's in the shanty because on Friday, the Sixth Circuit issued its decision in the OSHA ETS stay case. And the Sixth Circuit did that very late in the day. And when the guy who usually does this thing got home about 6:30 on Friday and made the mistake of opening his email, he said some very, very interesting words. Now, you know Santa can see you when you're sleeping, and he knows when you're awake. And the interesting words that came out of Mr. Palazzolo's mouth landed him straight on the naughty list. So Santa's here today, and we're going to talk about the Sixth Circuit's decision in the ETS mandate. And if you don't mind, we're going to do it this way, because it's hard to talk with that beard on. So, what exactly did the Sixth Circuit decide on Friday with respect to the OSHA ETS? You all know now that the stay has been lifted, so let's talk about what that means. We'll start with a little history so you all remember. Remember, on November 4th, OSHA issued its vaccine or test mandate that went into effect when it was published in the Federal Register on the 5th. Immediately, the Fifth Circuit entered a nationwide stay, preventing the mandate from going into effect, and OSHA honored that stay. Lawsuits were filed all over the country. Through the lottery system, the thing ended up in the Sixth Circuit, and the Sixth Circuit did a couple of things right away. Number one, they refused expedited review because they already had a case. And number two, last week or the week before, I can't remember which it is, they refused to hear the case en banc, which means with all the judges sitting, they were going to leave it to a 3-judge panel. That 3-judge panel issued its decision with respect to the stay on Friday. And it was a 2-1 decision with 2 judges agreeing and a concurring opinion and a dissent. And here's what the court said to start with, which I thought was very interesting. The judge who wrote the opinion for the court said, quote, "The ETS does not require anyone to be vaccinated. Rather, the ETS allows covered employers the option to require unvaccinated workers to wear a mask on the job and test for COVID-19 weekly. Or the employers can decide that they want a vaccine mandate. The court said, the employer, not OSHA, can require that its workers get vaccinated, something that countless employers across the country have already done." So that's how the court kind of started their opinion. And that's pretty telling, isn't it? So the court has shifted the mandate away from OSHA and on to the individual employers who are making the decisions regarding whether you have a vaccine mandate or you have a vaccine and test mandate. All right, so with that said, then what did the court do? The court then addressed the arguments for continuing the stay put forth by the petitioners. And the petitioners basically used the Fifth Circuit opinion as their guide, which makes sense. You've got a federal court already saying, here's why we think a stay is appropriate. You might as well use that as your arguments. And the court used the same 4-factor test that the Fifth Circuit used. Whether the stay applicant has made a strong showing that he's likely to succeed on the merits, whether the applicant will be irreparably injured absent a stay, whether the issuance of the stay will substantially injure the other parties interested in the proceeding, and where the public interest lies. Exact same standard, worded a little differently, than the Fifth Circuit used to put the stay in place in the first place. Only this time, the Sixth Circuit found exactly the opposite on every single point than the Fifth Circuit did. So what the court did in their opinion is they walked through all of those 4 factors, and they started with the likelihood to succeed on the merit. And that revolved around the Fifth Circuit's argument that OSHA had exceeded its authority. What the Sixth Circuit did here was they said, no, OSHA in fact didn't exceed its authority. They listed a laundry list of things that OSHA has done in the past that they said were very much like what this ETS says, and that OSHA hasn't exceeded its authority. In fact, OSHA is acting well within its authority. All right, the court noted that despite the Fifth Circuit's claim that the ETS is an overreach by OSHA, that amounts to a vast expansion of OSHA's authority under the ETS. Really, it's just another in a long history of OSHA properly exercising its existing authority to confront what they called a novel and dangerous hazard. In other words, basically what the court said is it's the pandemic that's different, not OSHA's authority, not OSHA's exercise of authority. But the court did a long and extensive analysis of its view of OSHA's authority and said this thing falls squarely within OSHA's authority. In fact, they even said OSHA has the right to order vaccines. They cited the bloodborne pathogen test as saying OSHA has a right to govern viruses in the workplace and pointed to specific language in the statute. In other words, they took the Fifth Circuit argument, they flipped it on its head, and they came out and said, we find that the petitioners are not likely to succeed on the merit, that in fact, we think OSHA has the authority to do this, and so the petitioners are not likely to succeed on the merit. Then they went into OSHA's authority under the statute, and they dealt with the issues of emergency and grave danger and necessity, just like the Fifth Circuit did. And they said that the findings of the court with the record in front of them, coupled with FDA-approved vaccines, more widespread testing capabilities, the recognition of the Delta variant and new variants, and they even talked about Omicron, support OSHA's conclusion that the current situation is an emergency and one that can be ameliorated by agency action. They also found that the pandemic amounted to grave danger. Now, you might remember that I felt going all along that maybe they'd have a hard time finding grave danger because we were so far along in the pandemic and we now had a vaccine and a number of people in the country were vaccinated and so on and so forth. The Sixth Circuit said, they hit this head on. They basically said the Fifth Circuit's conclusion, unadorned by precedent, that OSHA is required to make findings of exposure or at least the presence of COVID in all covered workplaces in order to find grave danger is simply wrong. Based on the wealth of information in the 153-page preamble, it is difficult to imagine what more OSHA could do or rely on to justify its finding that workers face a grave danger in the workplace. And then they dealt with the issue of necessity. And they said that the petitioners contend, relying on the Fifth Circuit decision, that the necessity of the ETS is undermined by the fact that it's both over-inclusive and under-inclusive. And the court simply said neither observation warrants a stay. OSHA may lean on the side of overprotection rather than underprotection when promulgating an ETS. And they said it's ridiculous to assume that OSHA would have to go and tailor a standard to meet each individual workplace. OSHA doesn't have the authority or the resources or the power or the time to do that. The court also touched on the constitutional questions that were raised in the Fifth Circuit opinion, basically dismissed those out of hand, just like the Fifth Circuit accepted those out of hand with very little analysis. They said the Commerce Clause clearly applies here. What OSHA is regulating is employers, not employees. This isn't individual decision-making. It's employer decision-making, and OSHA clearly has the authority to do that, and they've done that over and over again. And there was some other constitutional analysis the court simply disposed of. So that was the first thing, whether the petitioner was likely to succeed on the merits. And they said, no, we don't think you are petitioners. We think OSHA's going to win. Then they went to the next question, whether there would be irreparable injury absent a stay. And the court stated that the petitioner's arguments that they would suffer irreparable harm was offset by the fact that the ETS does not actually mandate a vaccine. And they went back to that argument that it's up to the employer to decide what to do, not the ETS. In other words, OSHA isn't making anybody get vaccinated. What OSHA is doing here is telling employers, you can make people get vaccinated, but if you choose not to make people get vaccinated, then they have to test every week and they have to wear masks while they're at work. And what the court said with that regard is that the mask and test option can't possibly amount to irreparable harm. That is, it's temporary in nature and does not create any irreparable injury. Yes, once you get a vaccination, you can't get the vaccination taken out of you. But in this case, you don't have to get the vaccination unless your employer makes you get the vaccination, which your employer has had a right to do all along. So the government isn't making you get vaccinated. What the government is saying to employers is, you have a choice. You could put a vaccine mandate in place, or you can make your people test, and that's an employer decision. And if the employer chooses the mask and test option, the employee gets the mask and test, and that's not irreparable harm. And if the employer chooses the vaccination option, that's the employer's choice. And if you can't get a vaccine because you've got a disability or because you have a sincerely held religious belief, those exceptions are still there. And then the court took the last two pieces of this four-part analysis and they pushed them together, okay? They said, in this case, because the government is not the petitioner, the government's on the other side of the case, the government and the public interest are basically the same thing here. And what the court said was that the public would suffer harm, as opposed to the petitioners in this case, and that the government, acting on behalf of the public, would suffer harm, because there was a reasonable belief that, as OSHA put it, at least 6,500 people might die and 250,000 people might be put in the hospital during the 6 months that we're fighting about whether or not this ETS should go into effect. So the court even said with Delta and Omicron, that number might even be low. Maybe more people will die and more people will be in the hospital. And clearly the public interest lies in having OSHA go in and try to ameliorate this danger in the workplace. So what the court said is, for the foregoing reasons, we grant the government's motion and dissolve the stay issued by the Fifth Circuit. So the stay is gone. What that means, folks, is that the stay is gone. So your question now is, okay, where are we now? What about the deadlines in the original ETS? We've already missed one of those deadlines in the original ETS. It was December 5th or 6th or whatever it was. You're right, you have. Well, the first thing you need to know is this. Some of the petitioners have all, this isn't the end of this, right? We've been saying all along, this is going to the Supreme Court of the United States. And some of the petitioners have already filed an emergency motions with the Supreme Court to put the stay back in place, okay? So that's already been done. Now, whether the Supreme Court will hear it or not, we don't know. The other option for petitioners is to file a motion to have the court hear the thing en banc. You've heard that word more in the last couple of weeks than you probably ever heard it in your life, en banc. That means the whole Sixth Circuit would hear it. We also already have a pretty good hint how the chief judge of the Sixth Circuit feels about this thing, because when they refused the initial en banc petition, he wrote a long opinion explaining why he felt the stay should stay in place. So if it goes to the en banc court, the stay might also get put back into place. But none of that helps us today. What do we do today? Well, fortunately, OSHA didn't wait to speak. They immediately went to their website and they immediately posted what they were going to do and what their feeling was with respect to this action by the Sixth Circuit. Here's what they said. I'm going to read it to you in full. Quote, OSHA is gratified the U.S. Court of Appeals for the Sixth Circuit dissolved the Fifth Circuit stay on the vaccination and testing emergency temporary standard. OSHA can now once again implement this vital workplace health standard, which will protect the health of workers by mitigating the spread of the unprecedented virus in the workplace. And here's the key for you. To account for any uncertainty created by the stay, OSHA is exercising enforcement discretion with respect to the compliance dates in the ETS. To provide employers with sufficient time to come into compliance, OSHA will not issue citations for noncompliance with any requirements of the ETS before January 10, and will not issue citations for noncompliance with the standards testing requirements before February 9, so long as an employer is exercising reasonable, good faith efforts to come into compliance with the standard. OSHA will work closely with the regulated community to provide compliance assistance. You get an extra month now. Not quite a month, about 20 days for the first date, because today, by the time you see this, is going to be the 20th. of December, and you've got until the 10th of January, so about 20 days to get that first part in compliance, and then until February 9th to start testing people who aren't vaccinated, and so on. So what does that mean? That means you got some work to do. That means we need a policy in place. That means we need to know the vaccine status of our people. That means we need to have an employee roster of the vaccine status of our people. That means we have to start providing time off, paid time off pursuant to the standard for people to get vaccinated. That means we have to provide PTO for recovering from the symptoms of the vaccine. If you're not sure what those requirements are, go take a look at the e-alert that we published probably today, probably before this. Take a look at that, and that will tell you what you need to do. Or get on the phone and give us a call. And also, don't forget, we have a policy that you can purchase that will get you started on getting in compliance with all of these requirements so that you'll be ready when that January 10 date comes around, assuming the Sixth Circuit or the Supreme Court doesn't act. That's the last time you are going to see me this year. And by me, I don't mean Santa Claus. I mean the Palazzolo guy. Unless something happens. And then we'll see. Have very, very happy holidays. Thank you all for all the support that we've gotten for this over the year. Your comments and emails are really, really appreciated. Happy holidays, everybody. We'll see you in the new year.